All right, let's get right into it. If you're prepping for the LSO paralegal exam, you know some topics are just absolutely critical. Well, this is one of them. Client management, fees, withdrawal. This stuff is everywhere on the exam. We're talking about the entire life cycle of a client relationship, and it's loaded with testable rules. So think of this as your high-yield study tool. We're going to help you spot the issues, know the rules, and absolutely nail these questions when that clock is ticking. Ready? Let's go.
So here's our game plan. We've broken it down into 6 parts. We'll start with the big picture, kind of the whole journey with the client. Then we'll get into key exam triggers, what to look for in a question. After that, we hit the core rules you've got to know cold. Then the tricky exceptions, the common exam traps they love to set. And finally, what happens when things go wrong. This is literally our roadmap to acing this chapter.
So why all the focus on this chapter? Simple. Managing a client relationship properly is one of your most fundamental professional duties. The exam is packed with questions on this because it's the perfect way to test your competence, your ethics, and your practice management skills all at once. Every single stage is fair game, and you need to know the rules for each one.
The easiest way to think about this is a 4-stage life cycle. First, you've got the initial screening. This is where you're asking yourself, can I even do this? Am I allowed to? And honestly, should I take this client on? Then, if it's a go, you move to engagement. That's where you lock it all down in a retainer agreement. Stage 3 is implementation. You're doing the actual work. And finally, you have disengagement. This is how the relationship ends, either because the job is done or because you have to withdraw. This timeline is your mental map for everything we're about to cover.
Okay, section 2. Let's put our exam hats on. A question is never going to just hand you the answer. It's going to give you a story, a fact pattern, with a red flag buried inside. Your job is to spot that trigger. Let's look at a couple of absolute classics. Here's a big one. A client comes to you and asks you to do something that's clearly outside the paralegal scope of practice. This should be a massive, flashing red light in your brain. The second you see this in a question, you should immediately be thinking about the rules on competence and scope. The answer is simple. You just can't do it.
Now this one's a little different. It's not about a hard rule you're breaking, but it is a huge warning sign. When you see this on the exam, they're testing your professional judgment. A client who's burned through 3 other paralegals? They might have totally unrealistic expectations or just be really, really difficult. You're not forbidden from taking them on, but you'd better be incredibly careful and manage that relationship with a rock-solid retainer from day one.
And here's the trigger that perfectly leads us into the next section. Your client isn't paying their bills. This happens all the time in real life, and it's a favorite for exam writers. It immediately brings up the question, can I withdraw my services? Well, can you just walk away? It's not that simple, and that's where the core rules come in.
All right, section 3. These are the non-negotiables, the foundational rules you absolutely must have memorized. When you're in that exam and the clock is ticking, you will not have time to be flipping through your materials to find these. You need to see the problem and instantly know the rule.
Let's start with your engagement letter, or retainer agreement. This is your contract with the client, and you can bet the exam will test you on what has to be in it. You've got to identify the client, nail down the scope of what you're doing, explain all the fees and costs, lay out how you'll communicate, and be super clear about what happens if they don't pay or if you need to withdraw. Knowing this list is absolutely crucial. You know, here's something that trips people up all the time. The word retainer can actually mean 3 different things. It can be the act of hiring you, like, I've retained a paralegal. It can be the physical agreement or contract, or it can be the money itself, the deposit that goes into your trust account. The exam will use it in all 3 ways, so you have to read the question carefully to know which one they mean. This right here is one of the most important rules in the entire profession. You cannot touch that client money in your trust account until you follow these 3 steps in this exact order. 1, you do the work. 2, you send a bill to the client for that work. 3, then, and only then, do you take the exact amount of that bill out of trust. If you mix up that order, it's called misappropriation. On the exam, it's a guaranteed wrong answer. In real life, it's a career-ending mistake. Memorize this sequence. Okay, let's level up. This is where the exam gets really tricky and starts to separate the candidates who kinda know the material from those who really know it. Knowing the basic rules is great, but the toughest questions are always hiding in the exceptions and the nuances. You have to know the difference between optional and mandatory withdrawal. It's a classic exam topic. Optional is when you may withdraw. It's your choice. This happens if there's a serious loss of confidence, like your client is lying to you, or if they don't pay your bills. But mandatory withdrawal is not a choice. You must get off the record. This is when the client fires you,
tells you to do something unethical, or you realize you're just not competent to handle it anymore. The exam loves to test you on the difference between may and must.
And let's dive deeper into that non-payment rule. In a normal civil case, you can usually withdraw if someone isn't paying you, as long as you give them notice and don't leave them in a terrible spot. But, and this is a huge but, in a quasi-criminal case, the rules change. If that trial date is just around the corner, you are not allowed to withdraw just because you haven't been paid. You have to stay on. Your duty to the court and to justice is more important in that moment. That is a highly testable exception. Okay, Section 5. Let's talk about the common traps. The people who write these exams know exactly which concepts trip students up year after year. So we're going to look at some of those specific traps, especially around fees and referrals, so you don't fall for them. All right, picture this scenario. Your accountant is amazing. They're always sending new business your way. You're grateful and you want to encourage them to keep doing it. So, can you pay them a little referral fee for every client they send over? What do you think?
And the answer is a big fat no. This is a huge exam trap. The rule is simple and it's absolute. You can only pay referral fees to another licensee. That means another paralegal or a lawyer. That's it. You cannot pay referral fee to an accountant, a real estate agent, your best friend, nobody who isn't licensed. It's strictly prohibited.
Now, when you are allowed to pay a referral fee to another licensee, you've got to know the numbers. The exam loves specific numbers. So the maximum fee is 15%, and that's on the first $50,000 of legal fees. It's just a number you have to burn into your brain.
And there's a ceiling. No matter how big the case gets, the absolute maximum referral fee you can pay on a single matter is $25,000. So you have the 15% rule, and then you have this $25,000 hard cap. Both are prime material for a multiple choice question.
Here's another spot people get confused. Fee division versus a referral fee. They are not the same thing. Fee division, or fee splitting, is when two licensees work on a file together and share the fee. The key is that the split has to be proportional to the work each person did, and the client has to agree to it. A referral fee is just a thank you for the introduction. The person who referred the client doesn't have to do any work on the file at all. Don't mix those two up on the exam. Last section. Let's talk about the stakes. It's one thing to know the rules for the exam, but it's also important to understand what happens when these rules are broken in the real world. This really drives home why they matter so much.
Let's be 100% clear on this. If you move money from your trust account to your general account before you've done the work and sent the bill, that's not just a bookkeeping error. That is misappropriation of client funds. It is one of the most serious things a licensee can do. And it's the same with withdrawal. If you just abandon a client right before a critical deadline, especially in a quasi-criminal case, that's not just bad service. The Law Society can deem that professional misconduct, and the consequences for your license can be severe. These rules are here to protect clients, even when the relationship is ending.
So I'll leave you with a final thought, a classic ethical problem. You're facing a tight court deadline. Your client is pushing you to put something in a document that you know isn't quite right, that it's misleading. So what do? Which duty comes first? Your duty to your client to get the work done on time? Or your duty as an officer of the court to be honest and not mislead anyone? The answer to that question is really the core of what it means to be a professional. Thanks so much for watching.